And so if you do nothing, right, if you do no estate planning, your family's going to end up in court talking to a judge, and they're going to look at the state statute and determine who represents you in court and where your property goes, okay? So what the will is going to do is it's going to replace those two things from state statute. It's going to say who you want to represent you. You're going to choose it rather than the court choosing it based on state statute, and where my property goes, right? Other than that, it's mostly the same experience.
Yeah.
With or without a will.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
This week's episode continues where we left off last week with our discussion addressing commonly asked questions about wills and trusts.
So now let's shift gears and let's contrast that with a will. And as you explained a few moments ago, it is important to understand that a will is something that, in the language of a Supreme Court justice, I think it was Holmes, that said, a will does not only speaks at death.
That's a great way to put it.
And so it's this piece of paper that really has no relevance to anything until you're dead. Mm-hmm. So unlike a trust where, there are rules in place and things that its purposes it's serving, a will serves no purpose and has no legal effect on anything. You may think that if you put something in your will that you've made some commitment that during your lifetime will be relevant. Wills have no relevance except at death. And now they may influence the way people treat you. So in that sense, they're probably very practical tools. But that's just an expectancy, unless there's a contract. And I don't want to get all law schoolish here, because you learn things when you go to law school, and immediately you're given a scenario where there's an exception to what you said. So lawyers tend to think that way the rest of their career. Well, I said something, but there is an exception. I don't think it will apply to any of you, but you could have a contract that would say you would commit to enforcement of this agreement. It would stay in effect until you die. You'd have to be paid to do that. Have you ever seen a contract enforced on a will?
I don't know that they're legal in every state anymore. I think the most common place we see something like that might even be a prenuptial agreement, right? Because
definitely that's relevant.
Yeah. You're going to say in that prenuptial agreement, here's our property, and we both agree to create estate planning documents that reflect this.
That's a good example.
Yeah.
So other than that, this piece of paper, we're not diminishing its importance, but John was, especially when he brought this up a while ago, was to make clear that this is doing nothing until you die.
Right. And so if you do nothing, right, if you do no estate planning, your family's going to end up in court talking to a judge, and they're going to look at the state statute and determine who represents you in court and where your property goes, okay? So what the will is going to do is it's going to replace those two things from state statute. It's going to say who you want to represent you. You're going to choose it rather than the court choosing it based on state statute, and where my property goes, right? Other than that, it's mostly the same experience.
Yeah.
With or without a will.
That's right. So wills, we're not critical of wills in the sense that if you don't have a trust, you definitely should have a will. Wills can allow you to suddenly be in control of what happens when you die versus a statute that's intended to apply to the entire universe of people within that jurisdiction. So wills are important, and we're going to talk about this because I'm not inclined to spend a whole lot of time with the will because I think many of you know some of the fundamentals about it. Although I should have us take a moment here and explain what happens when you die with a will versus a trust, just for some of those people that don't understand that a trust, is in effect the day you create it, and it continues in effect. And in a sense of the word, its continued operations go on as if nothing else happened the day you die. Now, there may be changes of employment in certain positions. When I say employment, a change of a position like a trustee, that may change. A beneficiary would change when you die if you were the beneficiary. So the person below you or persons would move up and suddenly be eligible for benefits, whereby previously perhaps they were relevant to none. Those things change, but the trust is going on business as usual. So the day you created it, it went into business, so to speak, and it stayed in business through deaths, national tragedies, acts of God. I mean, it's not something that just pops up when you die. Whereas a will is a document, as we said, it's not relevant till you die. But then when you die, there has to be a legal process by which there has to be a sorting out of your estate. There has to be determination of value. The assets have to be assembled in some fashion and accounted for. There has to be opportunities for creditors to come forward and be paid. There has to be publication and notification. There has to be an opportunity for people to challenge the validity of the will. There has to be somebody who comes forward and is appointed by the court. The court will continue its oversight of the whole process. I mean, if this sounds intrusive and heavy-handed, that's the nature of the process. It's intended to protect the dead, meaning the person who died, to protect their intention. So it has a good purpose, and it's intended to protect, of course, creditors and the rightful heirs. So those are all worthy purposes. But in order to achieve those purposes, all those things that you've heard, all those unpleasant things associated with probate, I've never heard anybody speak well of probate except lawyers. But it's not a process anybody wants to go through, and it consumes a significant part of the estate. But that's the way that it has to work for a will. Add what you would add to that, John.
I would say you're right. The will is your ticket into probate court, right? But I think if we take this back a level and try to understand why we're ending up in probate in the first place, we're looking at our assets, right? And we all own property, and that's what brings us into the need for this planning in the first place. Now, as you said earlier, we vary in the type of property we own. But if you've got any property, and what I'm specifically talking about here is titled property, right? And so if we distinguish between titled and personal property.
So when you say title, explain that.
Yeah. Let's explain personal property, what you're wearing, your clothes, your household goods, jewelry, anything that there's not a piece of paper somewhere that says you own it, we're going to call personal property. The way the law treats it is whoever's holding it owns it unless somebody can prove otherwise. When we're talking about titled property, we're talking about that stuff you own that there is a piece of paper that has your name on it. A deed for a house, a vehicle title for a car, a bank account has a statement and a signature card. All those things have your name on it, which is great during your life.
Versus somebody else's name.
That's right. You want to, if they come up and say, this is my Beamer, I'm going to say, no, it's not. It's mine, sir.
And it's definitely better if it's better than your ex-wife's name that would be on those things.
That is a great point. And so the problem that arises is while you're alive, it's great to have your name on your stuff. But when you're incapacitated, who can manage your property? It's got your name on it. Can your wife do it? Maybe. Can the child do it? Maybe. It depends upon what you've written on there. And then as far as who takes it when you're no longer here, that's really what we're talking about. When we talk about estate planning, we're planning for those two situations, when you're not alive or when you're unable to act, right? And so if it says your name on it and we've got no direction otherwise as to what's supposed to happen with it, that's how we end up in court. Because we don't have an answer, right? And we talk about this with trust and everything. If we ever get to a point where we don't have an answer, the only place we can go to get one is the judge.
Yeah,
right?
And that's something that with trust, one of our primary goals is to never end up that way with a trust. And if a trust is well written, it's not likely to end up that way at all. So we haven't spent a lot of time talking about the difference in costs associated with a one-time creation of a trust versus the probate process and all things we just described, in addition to paying for the will. Now, granted, you can order a form online, and and we won't do a show on the many ways in which that can go wrong, I'll say that even if you manage to get a will free, still, when you do the math on the cost of probate, the way that's determined, many people don't realize that lawyers don't get paid on that based upon the time they put in, unless the time they put in gets them even more than what the statute would give them. Then they can have the higher number. But no, you're probably going to be billed based on the value of those assets. A certain percentage under statute goes to the lawyer, or I say lawyer, the person who is the administrator of the trust, the personal representative of the trust, of the will. So whoever that person is, it could be very lucrative. It may not correlate the amount of effort. Often it's not necessarily associated with the value of the assets. You could have a $10 million single asset that is left when somebody dies, and according to statute, a percent of that will go, and I don't know the percentage off the top of my head, but the point is that there's a schedule of percentages that's applicable in Missouri and most states. So, so often for lawyers, if our interests were how to make the most money as an estate planning law firm, it would always be to do free wills. Do free wills. This wouldn't be ethical, but if the legal profession permitted you to say, I'll do a free will in exchange for your naming me as the personal representative of the estate, that would be a very lucrative arrangement for lawyers.
It would.
Because it's that the pay is very generous by statute. And as it turns out, you'll not be surprised to hear that a lot of legislators are lawyers.
Well, in Missouri, that percentage, if you had $1 million, it would take $50,000 out of the estate right off the top. 25 to the personal representative and 25 to the attorney, because they both get paid under that percentage.
So, and plus other costs.
Right.
So you can see how it can be very lucrative for lawyers to just recommend wills if a client is going to name them to be in charge. And so, at Cordell and Cordell, we prefer to make more money than less. But ultimately, we believe the way we succeed is to give advice to where clients are really, really grateful. They remember us. They go to dinner parties and whatnot, and they tell people how great we are. That is a more long-term perspective, but that's the way Cordell and Cordell has been built. And for estate planning practice group, we have that same long view. And so the long view is not how do we make money in the short term, but how do we build our reputation and client satisfaction so that over the next 30, 40, 50 years, our firm will grow as a law firm in the community and the many communities that we're in. So anyway, we've sort of given you a little bit of backstage insight from a legal perspective, how doing wills, though you think you may be ahead because you paid much less for the will itself than you would the trust. The trust would probably cost you several $1,000s, depending on the lawyer, depending on your circumstances too, of course. But when you compare that to the difference that ultimately you're out, but in the will scenario versus the trust, assuming you have a significant amount of assets, it's pretty dramatic. So it just makes more sense when you're thinking about the value of your investment to think about a trust rather than a will. That's the reason that our firm, naturally there are some exceptions to everything, but except for occasional exceptions, the general rule is trust makes so much more sense for people than wills. And it's easier to have people go forward with a will because the cost is very little. But ultimately, it's better for you to think about the value of what you're getting and how it correlates to the last third of your life. Remember, this estate planning includes other documents, and it should. Whether you go to Cordell and Cordell or someone else, you shouldn't let them just prepare a trust for you. You need to say, wait, I need to have all the accessories and things that are necessary for me to be able to get not only through my life, but beyond in the sense that the things you care about are taken care of. So that really requires a few other documents that we won't get into in the show. But it does mean you spend more when you go in and approach it in that holistic way, where you're thinking more about long-term value than getting by, then you are given a bigger number. And so sometimes people, being caught in the present, they can't think about the rest of their lives as much. And sometimes they fail to have in place those other documents along with their trust that assures that your needs, not your loved ones, your needs are taken care of for the balance of your life. And then that the needs of your loved ones are taken care of after that. So it's a little difficult to teach that. So one reason we like to do these shows is that it kind of does the advance work for people who come into our office to know the things that we've been saying, and it allows that meeting to be much more effective. Now, one thing I want to get to before we wrap up here on this topic is I want to put a little bit more flesh on this description of probate. We say, well, probate is an unpleasant experience. We've told you it's expensive, but there are delays associated with it that are just necessary. So while no one wants to be in probate for 2, 3, I mean, you all know the stories. We've done stories on Life's Third Act where it's gone on for 10 years. Mm-hmm. So you may think, well, gee, what an abuse of grieving people. But when you think about what it has to accomplish, it's not real simple. So we're going to take maybe we can do this. Maybe you can do this in 5 minutes, John.
Yeah.
Just describe what the probate process is. We've said who it's for.
Right. For everyone, right? And
Yeah.
I think that's the biggest distinction. When you've done this trust and created this agreement, you're saying, these are the people I care about, and this is who I want you to focus on. When you don't give that direction, the court includes anybody that could be an interested party, right? And so they're giving notice to spouses, they're giving notice to children. You're publishing notice in a local newspaper so that any creditor that you've ever had has a chance to get their piece of your estate, right?
Which is important. I mean, if you're a creditor of somebody who dies, you didn't sell them a good or lend them money or whatever you did as a business person with the condition that if they die, they don't owe it.
Mm-hmm. But
Yeah.
if you are the creditor, we could do them a favor right now and tell them 6 months or 1 year, right? These are the numbers you've got to be aware of if you are doing business with somebody that passes away. In the state of Missouri, you've got 1 year, and the responsibility is on you to bring your claim forward.
Assuming that it was advertised, right?
Well, that's if it hasn't been advertised. The moment it's published, you've got 6 months from the date of publication to file your claim in the court, right? But essentially, by opening up a probate estate, you're doing the creditor a favor because you're giving them a venue to file their claim, right? If you never open up the probate estate, which is what would happen if you had a trust, the creditor has to open up the probate estate themselves. They got to go to the court and say, this person passed on this day. They owed me this much money. Here's my claim. And it's a little bit more expensive and more difficult. Doesn't happen as often.
And that's a very interesting point. We don't dwell on that as an advantage very much because most of our clients intend to have their bills paid. But somebody who felt something wasn't a legitimate claim, maybe a lawsuit that would potentially could have been filed or something, it is a little more work and vigilance when there's a trust than the notification process that you were just describing.
Mm-hmm. And so you filed that petition with the court. Somebody stepped forward, right? Nothing happens on its own. Let's first say that, right? If there's property there and there's nobody named on it, somebody's got to step forward and petition the court and say, this person passed, this is what they owned, where does it go, right? And so that's step one. Then the court looks at it, approves it, and will name whoever they determine is the best person to manage your property, right? And once that's happened, that person then has to go around and collect everything you own, and make an inventory of it. File that with the court.
And they file that under oath with the court. So it's a solemn responsibility to, and you might think, well, gee, that sounds like a difficult task. How do you figure out what someone owned? Because there may not be one single place in which they've ever listed the things they own.
Mm-hmm. And that's something they'll get from us if they do plan with us, is a binder that they can collect all that important information. Because believe me, I've been in plenty of homes where there's a box in the attic, there's important documents next to the bed, there's something in the basement, right?
You just described most people.
Right.
I mean, that's not unusual.
It's not. And as your life, you're thinking about, I need to keep this safe. And that's almost the exact opposite of what you need to do when you're gone. They need to be able to find that stuff, right?
Yeah.
And so making sure that's all in a place where they can then collect that information, whether they're going to go through the court under the will or administer it under the trust. And so that's just the beginning of the process. They filed the inventory. And when that inventory files is the same time as publication is going to happen, and that's when that's 6 months. And this is what happens that really lengthens a probate estate. There's no doing it quick, right? Because you've at least got to do that 6 months for publication for all creditors before you can even start to close out the estate. So you're probably at about 8 months by the time that happens if you've done everything really diligently. which most people haven't. I mean, this isn't the first thing we do when somebody passes. We don't leave the funeral and head right to the courthouse. You need some time to grieve, you know?
But then what if somebody challenges something? They say either there was undue influence or that there was forgery or fraud or deception.
Yeah. That'll lengthen the probate process extremely, right? Because then you've begun a fight. And the moment you end up in some kind of litigation regarding this, you've lost control of what's going to happen there, and you're going to wait until that litigation is complete before you can close out the probate estate.
So everything's tied up while a lawsuit goes forward. And I know all of you have either personally or you know of people who've had lawsuits, and you know those often take years. And so your probate estate is on hold. I mean, imagine all these assets that you want to get to those who you care about. That plan is on the shelf.
I'll tell you, Joe, I was sitting in front of a judge the other day, and I was complaining because we were trying to close out this estate. And I said, we're almost past a year, Judge, and I'd really like to get this done. And he looked at me and said, Mr. Sauter, I think you're doing a really good job if you're getting this done in a year. And we're going to try to get everybody done as quick as we possibly can when we're in probate court. But it's his reality that these things extend much beyond years in many circumstances.
Yeah. So that's just that. This is just to give you a general understanding that this is why probate exists. You've got to give a chance for people to be paid. You have to determine the will's valid, and you have to determine who is the right person to get it according to the will. One thing that I want us to clear up in closing, it's not as if it's what we propose and what we're convinced is the absolute best thing for the vast majority of you, without question. It's not as if it's just trust versus will. At the risk of confusing you, even when we do a trust, we always backstop that with what's called a pour-over will. It's just a will that says nothing more than anything that happens to be in my estate, in other words, not in my trust, at the time I die. In other words, you may choose, if you create a trust, to have some things you don't put in it. That's not unusual. But you want to be sure that you have a net below that catches those things and makes it clear that all you need to do is dump it into the trust, into the box. So that's all a pour-over will is. It's just like it sounds like. It says, take any stuff that wasn't already in my trust. Remember, it's in the trust. It doesn't go in probate. So anything that's in the trust is not subject to probate. But it's not a disaster if you have some assets that end up going through probate because you didn't have them in the trust. Because clients often say, well, I don't want to prepare a document of title for, a new car I got or certain things that they may choose. And we tell them, look, it's not a big deal. But what would happen then is we'll have prepared for you anyway this net will. By net, I mean something to capture whatever isn't in your trust, and it's going to end up in your trust. Maybe delayed a while. You may pay some fees, we've discussed, but it'll end up in that box.
Right.
So just so you're clear, we're not advocating just a trust versus just a will. We're saying we do the trust, then we do this pour-over will, which is not very expensive to you. Of all the costs that you pay when you do the planning, these documents we referred to today, whether it's us or another law firm, I can tell you very little of it is going to the pour-over will. The pour-over will is very brief and straightforward. It's the other documents that, require the sort of attention that we've talked about today.
And we package all that up, right? And so you don't have to worry about, am I getting everything I need?
Yeah.
Because when you get a trust package at Cordell, you're getting everything you need.
Yeah.
And that's why we always use that box analogy too, right? If it doesn't get in the box, the will cover it. I think you cover that really well.
Yeah. And of course, we know that you're not capable. You don't know. It's like if I go to a surgeon and he hands me a menu and says, which of these things do you want me to do? I would say, well, which of the things do you need to do? And so we realize that you're kind of in that position. So we don't want to simply say, well, we have a bunch of documents here you could choose from. We say to you, look, this is what you need. These things work in a systematic way. And they cover all the bases, they cover the possibilities, and they give you the most security. It's one of the best investments you'll make in your entire life. I know it sounds self-serving because you pay us to do that, but I'm just telling you it's a fact. And I've said this to people I will never represent. people I've met in other cities. When I'm in Florida, sometimes estate planning will come up, and we don't have an estate planner in Naples, for example. But I tell them, in terms of priorities, this should be number one.
Mm-hmm.
So
we don't have one there yet.
Yeah, working on it.
Yeah, that's right.
We don't have trouble getting volunteers.
We'll be in Jacksonville shortly.
Yeah. Well, if we can get them to jump on a plane and fly to Jacksonville. So anyway, we hope this has been helpful to you. So we've covered the first question today, and this will be a series in which we'll work through these 8 topics. And I think all of them will be helpful to you, but at least you can pick and choose the things you want to watch. John is very knowledgeable about what he does. I haven't actually done probate work versus estate planning. I haven't done probate work in many years. So probate is it's its own thing. And because we focus on the things we've been talking about here, we're not in court doing that a lot, but we do have clients, as John just described, who maybe they had someone else do their estate planning and they didn't have anything in trust. Maybe they had some things in trust and they had other things, though, that weren't. And so John is very knowledgeable about the probate process. So I lean on him for that information and much other information. So one other thing I want to mention in closing is we have a deal that we've really had going for a time now. We intend to continue it because we're building our estate planning group at Cordell and Cordell. We're very excited about it. We've been giving a discount of 15% to anybody who mentions this show. And this is not just a fictional 15%. This is the actual amount we'll take from what you would otherwise pay if you have these services done at Cordell and Cordell. So we're happy to do that because we want to encourage people to come to the estate planning group, to watch these shows, to gain the benefit. We're building that practice out. We think the future of Cordell and Cordell will be that this group will probably be the largest part of our practice in another 15 years or so. We don't know. Cordell and Cordell started out as just domestic relations. We were just domestic relations for many years. And it occurred to us, estate planning is such a related topic. In other words, they come under the banner of family law. Well, there's a reason that those are associated, is that often those issues associated with divorce and separate property, marital property, planning, with all the things that are associated with that, have a huge impact on your estate plan and vice versa. So we're able to bring to the subject of estate planning a perspective that most law firms can't. If they've just done estate planning, naturally, they don't know the things about domestic relations that can tie into that can have implications. So we can plan for concerns like that in a special way. Not to mention people who've been divorced, naturally, they have a perspective about how they want to take care of children in a blended marriage, for example, to protect their children and to be fair to the stepchildren as well. So our background in domestic relations, of course, serves us there. But in any case, we are growing our estate planning group. We're excited about it, and we want to give it momentum. So we don't do this at Cordell and Cordell for the domestic relations division, but we are doing this for the estate planning group. And it's a 15% discount. Mention, though, that you saw it on this show. Anyway, we will be back with our next episode to continue working through this 8-point list of the most commonly asked questions on YouTube about estate planning. Till next time, take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell and Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.